Hello and welcome, everybody. Apologies for the delay, but thanks for hanging in with us. Uh, my name is Matt Mahoney, the Director of Government Affairs for the Pennsylvania Solar Center, and thank you all for joining us today for a conversation on the Pennsylvania Solar Guidebook for landowners leasing property for large-scale developers. Uh, I am usually joined by Sharon Pillar, but she is out of the office today. So you're stuck with me, but uh, we will hopefully have a seamless program for the agenda today. We'll do our typical overview of the Pennsylvania Solar Center with a few updates on legislative activities following some outreach we had done in Harrisburg this past week. And then we'll jump right into the content with Michael Parker, who's joining me today, the Executive Director and Managing Attorney for Fair Shake Environmental Legal Services, and we'll certainly leave lots of time for Q&A, and hopefully we will be able to enable the chats. So like I said, often we're usually joined by Sharon Pillar, but unfortunately not here today. But the organization she has built, the Pennsylvania Solar Center, has a vision of ensuring that all Pennsylvanians can benefit from solar. So apologies for the mishaps in the slides. But you could see our supporters here. We're supported by a wide variety of different funders, different businesses, and we're always appreciative of those that provide financial support as well as support in other ways through engagement and other activities. So if anybody's interested in joining this group of supporters, please reach out. We're happy to have a conversation and find ways to increase that support. So some of the work that we do, we break our work down into three buckets, into transform, educate, and advocate. And transform, we really work with commercial scale, large scale solar owners or those that are looking for solar, provide that technical and financial analysis and a technical analysis to help folks go solar. And we also host informational activities such as this on solar resources and other information regarding the solar industry here in Pennsylvania. And then, of course, our policy advocacy work, which I'll jump into a little bit later. Our Get Solar program is up and running and has been for quite some time now. And we've been receiving a flood of applications, and we're so gracious and happy to see so much interest. And we encourage folks that are interested in learning more about Get Solar to check out our website. But this chart here breaks down some of the numbers from what we're seeing and where we're seeing those applications come from. A lot of municipalities and nonprofits, businesses and faith communities that we're working with to help evaluate the potential for solar on their properties and to help them access the benefits of solar. Our Get Solar Communities program is up and running. We've initiated pilot projects and we're pushing forward with round 3. There's lots of support that's included in our Get Solar Communities program, where there's toolkits for media to help support outreach, and continued technical support from the Pennsylvania Solar Center for those communities to help see more installations of solar throughout these communities. And if anybody's interested in learning more, please again reach out. We also have our Pennsylvania Solar Center, our partnership with Generation 180, where we're working with schools to evaluate the potential for solar on their schools, and this partnership has been very helpful in increasing awareness with schools and increasing information access for superintendents and schools. Our outreach and resources are always available, such as through programs like our Watson Learn. Our website contains maps and other resources to identify where solar installations are or look for new solar contractors. We also recognize those champions in the solar world through our Lodestar Awards and regularly through our newsletter. So if anybody would like to learn more, please check us out. Now into the policy and advocacy space, which is where I'm usually residing. We put together a legislative guide that covers all of the solar policies in Pennsylvania. This guide is regularly updated and includes helpful links that'll take you right to the legislation, as well as a bit of an analysis on what we think the policy is trying to do and how it would impact the solar industry. So we're keeping our finger on the pulse of what's going on in Harrisburg with regard to renewable energy policy, and I'll fill more in about that. But these are our top priorities, what we're really pushing for to see in Pennsylvania, seeing Pennsylvania go 30% renewables by 2030 and enhance our current solar carve-out and increasing that to at least 14%. And we want to see more diversification of Pennsylvania's electricity mix. And we think renewables are a great diversification approach. And it also expands market opportunities through jobs and investments. We also want to are working to advocate to enable community solar, which helps improve access to solar, and also defend consumer protections, ensuring that consumers are protected when community solar is enabled in Pennsylvania. And then, of course, always defending against unfriendly solar policies. So as I've mentioned, we had a brief meeting or a brief lobby day this past week in Harrisburg, where we met with several members of the House in Pennsylvania to advocate for support for a bill that would increase the renewable energy standards or the renewable energy goals in Pennsylvania's alternative energy portfolio standards. Currently, our standards are quite low, and when compared to states in the surrounding area, fail to compare and has impacts on the solar market in Pennsylvania. When investors are evaluating where their potential investment potential may have the best return on investment, looking at Pennsylvania may not be as robust as it would be in neighboring states. So it's really important to improve the solar goals, the renewable energy goals in Pennsylvania. And we heard a lot of that from legislators. The reason this issue is so critical right now is because the goals that were established in 2004 have been met as of 2021. And so with that, those goals being met, there are no longer increases in the goals. So the goals are going to remain the same as this bar graph shows. Until we get to a point where we can increase those goals, we're going to see the value of the renewable energy credits and the credits that are generated from the alternative energy portfolio standard. We're going to see the value of those start to deteriorate. And we're seeing that happen now as the market prices in Pennsylvania for SRECs are dropping significantly. Year over year have dropped 30%, which is the wrong way to go. We need to see 30% renewable energy by 2030 and not 30% reductions in the price for our SRECs. The SRECs are an important value, a component of the value stack for those that own solar, provides an important revenue stream to support those that are using solar, and ensures, again, that our electricity mix is diverse and that we're bringing more renewable energy online. So this is sad news, and we're working hard in Harrisburg, and there are a lot of committed legislators in Harrisburg that are working to advance, but we need to continue pushing. And to those that have supported this work in the past, thank you. As I mentioned, our electricity mix is getting a bit less diverse, and that has impacts on consumers as well. When we're confined to just one energy resource, we become more coupled with that energy resources, how it reacts to different market impacts. So just as we saw in the summer of 2022, when natural gas prices increased because of issues outside of anyone's control, because Pennsylvania has so much electricity that's generated from natural gas, we saw electricity prices increase as well. So that diversification alternative energy portfolio standard helps that with that diversification and ensures that we're increasing, we're incorporating different components and allowing, not allowing one commodity market to dictate electricity prices. House Bill 1467 and Senate Bill 230. This is the bill that we were in Harrisburg lobbying for this past Tuesday. where we were able to get 7 more co-sponsors to join the bill. So we're very happy to be up to 38 co-sponsors that have joined House Bill 1467, and that bill would increase the goals from the Tier 1 renewable energy goals to 30% by 2030. It would also enable community solar, a very easy lift that we can accomplish, and to help take advantage of some more federal programs, but also the point being, again, increasing access to solar for more Pennsylvanians. And then, of course, we want to recognize each of the solar industries respectively within the APS, making sure that customer generators aren't competing against grid scale, large scale, with regard to the credit markets. And then, of course, community solar. This graph, I think I've shown it before, but shows the breakdown of how the percentages would play out based on where we are now. Our goal is 0.5%. We need to increase dramatically to keep pace and to ensure that we're bringing more renewable energy online in Pennsylvania. So Pennsylvania can win a lot with just going 10% solar. Billions in investment and economic development opportunity, hundreds of thousands of jobs that are created, local tax revenue for communities. And when we start to diversify with solar, we start to bring the electricity prices down and stabilize them for all consumers. So again, everybody wins, and it's an economic development opportunity. So for those that have already taken action, please, thank you very much, and continue to let your legislators know that you care. For those that haven't, the top QR code will take you to an action alert where you can find your legislator and send them a note to let them and to ask them to support House Bill 1467. And you can find your legislator with the QR code there at the bottom. So now shifting to the contents of today, why we all registered to attend today's webinar. We're here to happily announce that the Guidebook for Pennsylvania Landowners that has been developed in partnership with Fair Shake Environmental Legal Services and the Pennsylvania Solar Center has been completed and finalized, and we'll be circulating a link for that guidebook here in a moment. But wanted to first recognize the partnership and the work that was required to pull this together. It took many hours of legal research from the incredible team that Michael at Fair Shake and his team have put together. It's been incredible working with them, and this is an important tool and an important time for landowners. So we're very excited to be partnering and working with Fair Shake Environmental Legal Services on the development of this guidebook, but also for those that have questions and really need the advice and counsel of a legal expert. I think we're building good capacity, and Michael and his team at Fair Shake have built a tremendous amount of capacity in this space. So we're really happy to have worked with them and put this together. But it's not just Michael. I have to give props, scatter the props broadly. A lot of industry inputs, a lot of input from a wide variety of stakeholders, from the civil sector, the economic sectors, as well as community-based organizations and government representatives. So we've done our due diligence and sort of outreach, and Michael again and his team have been able to pull together a lot of these different issues and comments and input, and put together a very solid product that will hopefully be of good use and value for landowners in Pennsylvania. So with that being said, I'm happy to introduce Michael Parker, Executive Director and Managing Attorney for Fair Shake Environmental Legal Services. And I'm going to pass the mic immediately over to you so you can jump into the content. So thank you so much, Michael, for being here. And please take it away.
Well, thank you, Matt. I really appreciate that introduction. And I just want to say at the onset that we also here at Fair Shake really appreciate the opportunity to work with the Pennsylvania Solar Center on this very worthy project. We agree that it's very important for landowners to have a good understanding of the landscape here as they entertain lease proposals and think about what they can do with their land. So as Matt noted, my name is Michael Parker. I'm the Executive Director and Managing Attorney at Fair Shake Environmental Legal Services. The next slide, Matt. And some of you may not be real familiar with who Fair Shake is. We're a fairly new organization. We've been around for 10 years. We actually just had our 10-year anniversary celebration back in September. We're a nonprofit law firm formed in 2013 with a kind of a three-pronged mission. Our main mission is to provide access to environmental justice. We also work to empower and enable communities to make their own economic and environmental decisions. And we also have a legal education component to our mission where we provide training to young attorneys in public interest environmental law. And our mission, if you could do the next slide, Matt. Our mission breaks down into three programs. We have our legal services program, which you would expect from a nonprofit law firm. And there's three kind of separate approaches that we have to our legal services, three models. One of those is our pro bono program, which accounts for about 20% of our docket. So about 20% of our cases, we charge no legal fees. And the clients that are eligible for pro bono rates are individuals and families with an income below 300% of the federal poverty level. Folks above that level, we give a sliding scale to. So our services are only the higher income people pay full rates for our services. Moderate income folks and organizations are somewhere on the sliding scale, and that accounts for about 50% of our docket. And then the remaining portion of our docket, we have public interest cases where we represent typically larger organizations on issues where we're trying to move the policy needle on some environmental issue. One of our other programs at Fair Shake is the Community Democracy Program, and this is a fairly new program for us. And through it, we work to achieve our community empowerment prong of our mission. So in the Community Democracy Program, we do several things. First, we do community visioning, we do engagement consulting, we do public education and advocacy, and we do all these things in communities to, we like to use a medical analogy to kind of explain the differences between our Community Democracy Program and our Legal Services Program. Our Legal Services Program, we liken to emergency medicine. There's been a problem. Our clients are hurt, they're damaged, and they need someone to help them fix that problem. So that's kind of like emergency medicine. Our Community Democracy Program, our partners and clients in the Community Democracy Program, it's the bad thing hasn't happened yet. We're trying to get ahead of it. We're trying to be proactive and enable these communities to make their own choices regarding the type of development that they want in their communities. And then our legal education program, we have resident attorneys who are kind of like resident physicians. They're already trained licensed attorneys who are looking to get some additional training in public interest, environmental law, and law practice management. So we have a 2-year program training young attorneys in both of those things. We also have legal fellows and legal interns, pretty robust internship program that actually covers more than just legal interns. We have undergraduate, graduate, and legal interns in our organization. Next slide, Matt. And just to note, as we're going in, this variety of programs and legal work that we have at Fair Shake has given us considerable experience in energy-related practice areas, including oil and gas lease agreements, oil and gas environmental permitting, public utility law, land use and zoning, Clean Air Act and Clean Air Water Act permitting, and large-scale solar leasing. So we've done this work, and it's a good bit of this work, and it's been very helpful as we've gone through this process and helped Pennsylvania Solar Center draft this wonderful guidebook. And as usual, anytime us attorneys give a presentation and start getting into the substance of an educational presentation, I have to give this disclaimer. This presentation is only for informational purposes. I'm not creating a lawyer-client relationship with anyone here, and it shouldn't be construed as legal advice. If you do need legal advice, I'm very happy to provide that, but that's the type of thing that really is best done offline and not in a Q&A session or anything like that. So please feel free to reach out if you have very specific questions and require legal advice, and we can begin that conversation. Finally, just want to note that this presentation does not represent the views of my organization as a whole. I did not get it approved by my board of directors beforehand or anything like that. So any views expressed here are my views and not the views of Fair Shake. Now, getting into the solar guidebooks here, and there are two of them. This is the first of two. This is the landowner one. There's a municipal guidebook that's forthcoming that we're still working on. And both of them went through a very similar process while we were drafting. We began with legal and factual research, and this was done in part by my team here at Fair Shake, where we had two attorneys going through the public record and researching laws. We also had two industry stakeholder focus groups, and earlier Matt showed a slide that listed the industry folks that helped with this process. And I want to, if any of you are on this call here, I want to thank you again. And in that process, that stakeholder process, we really delved into the nuts and bolts from start to finish of a solar project and the solar development process. And we use that information to inform what we wrote here in this book. We also had a stakeholder process with government folks and advocates. And that was not a focus group. We did individual interviews with those folks, and we really picked their brain about their views on the process and where we are with solar and where we're going. And then finally, after we've drafted both books, we presented them to the stakeholders that we interacted with here and got their comments after they reviewed the drafts to make sure that we were accurate with what we included. Now, getting into what we did with the guidebooks, I'll just quickly go over the table of contents. So if you could go to the next slide, Matt. So this is basically the table of contents of the landowner guidebook, and we begin with an introduction, which is what you would expect. We go over some of the basics. The setting the stage for solar goes over, really what type of solar projects are out there, the types of land used. Then there's farming and rural land considerations that we go over. That's really touching on farmland preservation, agri-solar, which is a term used to describe co-location of agricultural production with solar power generation. I missed probably one of the more important chapters here is the landowner considerations in the solar lease, where we go through really what a landowner needs to be thinking about as they engage a developer in the solar process, solar leasing process. And then we also go through an actual solar lease. We just describe what the various components of the lease are, some best practices and provisions that land ownership ask for, and really go through the stages of what they can anticipate in the leasing process. Then there's a chapter on other considerations and looking forward, and that chapter goes through some thoughts about community solar and then does some myth busting. There's a lot of myths about solar floating around out there, and we address some of those. And then we have a conclusory chapter and then some appendices that goes over in greater detail the regulatory process, the permitting process, zoning and municipal ordinances, as well as includes a sample lease agreement. Now, I'm going to go into each of these chapters with a little more detail so you can get a better flavor of where we're going, what we've done with this book, and the types of information you can find in it. In the first chapter, which again is the introduction, we start with a section on what is solar energy. And that's really that's the very most basic, like 101. Explain it to me like I'm a 5-year-old type of information about what is solar energy, the renewable nature of it, and where we're going with it. Solar is projected to be at least 20% of our electrical generating capacity by 2050. So it's going to continue to grow. It's going to continue to be a part of our society and our economy. And solar is very beneficial to many, and that's what we get at with the Pennsylvania Solar Future section. It provides local jobs, it increases energy security, it helps to decarbonize our energy supply, it boosts the economy, preserves farmland from residential development, and provides much needed income to rural landowners. And because of these many benefits, it is part of our future in Pennsylvania, and it is going to continue to be part of our future. We also briefly go over some of the financial drivers of solar, large-scale solar. And large-scale solar really does need financial drivers as a young industry. It's a very cost-intensive industry. It requires significant upfront capital expenditures. And those costs includes land acquisition and development, interconnection fees, one of the considerations for cost is proximity to transmission lines. The further from a transmission line, the more it will cost the developer to get the power to market. Supply costs, that's a definite factor these days, and the like. So to support this industry's growth, government at various levels have created some financial incentives. There's the investment tax credit on the federal level, which provides a 20 to 50% tax credit for the value of the project. Then there's the production tax credit, where there's payments received for solar power production over a 10-year period. There's also modified accelerated cost recovery system, which is another financial incentive. And that allows a solar company to depreciate the value of their assets much faster than normal, which amounts to about another 25 to 30% cost savings. Power purchase agreements are important financial consideration for developers, and we outline that. It's important to developers because it allows them certainty in their market. They can set the rate with a contract with a purchaser for an extended period of time, and it guarantees them a market for their power. Finally, the Pennsylvania Alternative Energy Portfolio Standard Act, as Matt noted earlier, as another financial driver for the program. The solar renewable energy credits that Matt mentioned are important to help reduce the costs of these, again, capital intensive projects. And the value of those credits are going down over time, which is why we need some policy changes to increase the required mix of solar in Pennsylvania's energy generation. And then finally, in this chapter, we review some of the very important aspects of why landowners are important to this process. They're stewards of the land. They hold most of the land in Pennsylvania and manage and maintain it. And utility scale solar really does require a good bit of land. Solar power requires about 5 acres per megawatt of power created. And utility scale solar projects are typically at least 20 megawatts. So you're looking at about 100 acres minimum for one of these large utility scale or grid scale projects. So that land comes from somewhere. Solar developers typically don't purchase that land, so they lease it from existing landowners in our communities. So landowners are very essential to the growth of the solar industry, and it is a complex process. So as you'll see as we get into some of the leasing details, these leases are very complex legally. So we really do recommend throughout the guidebook that landowners should really turn to professionals for advice, attorneys, land use specialists, places, advocacy organizations and education organizations like Pennsylvania Solar Center, all can help a landowner understand this process and get the advice they need to make well-informed decisions. Moving on to Chapter 2. Chapter 2 sets the stage for solar. In this, we talk about who are the stakeholders in this process. The stakeholders include the developer, obviously, off-takers, and I'll describe who those are in a moment, utility companies, the landowner, municipalities, and regulatory agencies. Who are the developers? I mean, that's pretty obvious. They're the entities, companies that are designing, building, owning, and operating a solar facility. And it should be noted that this is very much plural. a developer for a single project, there could be more than one developer. Different entities could do the leasing process, do the development process, and then there'd be a whole other entity that might be operating it after the fact. So landowners should expect to potentially be dealing with multiple companies throughout this process. Off-takers and utility companies provide a similar role in this process. They're the ultimate consumers, the initial consumers, let's put it that way, or maybe the ultimate consumers of the power generated at a large-scale solar project. Off-takers are who a developer may contract with through a power purchase agreement to purchase the power generated over a long period of time, creating certainty for the developer and for the off-taker, so everyone knows what prices they're dealing with for an extended period of time. Utility companies also purchase the power from developers or operators of solar facilities, rather. And they're also involved in the planning process because they're involved in interconnection approvals. Again, landowners are super important to this process. They own most of the land, and solar developers really need to turn to them to make these projects happen, which is why we're helping support them in this process. And the municipalities and regulatory agencies are, of course, involved. Anytime there's a large tract of land being developed, there's going to be approvals on both the municipal and state level. And then there's also going to be state land preservation programs that are dealt with, and we touch on that a bit in a moment. We also discussed the different types of solar. There's distributed, community, and large, or sometimes called grid scale solar. Distributed is what we would see on our homes and on our businesses. So these are larger projects designed to power a single building and offset electrical costs for that owner through net metering. And we're not going to get into net metering or anything here. That's really for a different presentation. There's also community scale solar, which Matt noted earlier is important for equity in solar. It enables folks who would not normally be able to avail themselves of solar power to do so through a subscription process to a smaller project, typically around 5 megawatts, where someone who may be a renter or may not have a lot of land or a lot of rooftop, they can subscribe and purchase their power through a community solar project. And then the large or grid scale, utility scale, there's a couple different ways to describe these projects. These are the really big ones designed to put power directly into the grid and supply power through the utility system. We also talk a little bit about in this chapter about the types of land that are suitable for large-scale solar. And there are a variety of characteristics that a developer is going to look for. And this is something the landowner should keep in mind as they're engaging with potential developers. Slope is a big factor. The slope of the land, the flatter, the better. If it's not flat, another factor that the developer is going to look at is whether the slope is south-facing. If it's a south-facing slope, they can generate more power from it. Wetlands, proximity to wetlands is always going to be a concern for any type of development, whether it's solar or residential or commercial or industrial. Wetlands trigger a variety of environmental permitting issues that can really complicate a process. So, if there's wetlands involved, that might be a negative for site selection. As I noted earlier, proximity to grid infrastructure for interconnection is a big deal for selecting a site for solar development, and we lay that out in this chapter. The amount and type of vegetation at a site is important as well. If there's a lot of trees that need to be cut down to facilitate solar, that's not great for the environment. We typically don't want to be cutting down mature trees, but it also increases the cost of a solar facility, and if it increases the cost for a developer, it will decrease the rent payments that a landowner might expect from a project. So the amount and type of vegetation at a potential site does influence these things. So in addition to these other issues in Chapter 2, we also briefly touch on the municipal and state approvals for a solar project and the best practices that a landowner should use when approaching those processes. We do this not because the landowner is responsible for obtaining these permits and approvals from municipal governments and state governments, but because the lease will require a landowner to cooperate with these processes. The developer, these leases are always going to have a clause that says the landowner has to allow the developer onto the property to do evaluations for permitting purposes. It requires the landowner to participate in the permitting process by signing any necessary forms or giving any necessary approvals. Also, if there's a legal challenge, say, for instance, the developer gets a permit issued from the State Department of Environmental Protection, there might be a provision in that permit that's detrimental to the developer, so they appeal it. If necessary, the landowner will be required to cooperate and participate in any legal action to support the project. So we include in this guidebook an initial brief overview in the main text, and then in the appendices, which we'll get to in a bit, we go into some detail of what these different permitting processes look like. Finally, in this chapter, we review the state land preservation programs, such as the Clean and Green program, that can impact or even prevent solar development. So using Clean and Green as an example, so some of you may not know what Clean and Green is. Clean and Green is a tax credit program for farmland preservation in Pennsylvania. And if a landowner enrolls in this program, it limits the type of activity that can happen in land enrolled in the program. And it does limit solar. A Clean and Green enrolled property cannot have an industrial scale solar facility installed on it. So it would make them ineligible for those tax credits. And once it's installed, they would be required to pay back any tax credits that have already accrued. So that is something that we cover in this chapter. And we also cover a little bit later when we talk about some lease terms, because often the developer will pay for those tax consequences for the landowner and pay back the tax credits for the landowner, so the landowner doesn't have to cover that cost. Finally, in addition to the land preservation programs that might be at issue in Pennsylvania for solar projects, we also briefly discuss the ways the Commonwealth will regulate large solar installations under various environmental permitting programs, such as the NIPDES program. And the NIPDES stands for those of you who may not know, it's the Clean Water Act permitting program. And NIPDES is an acronym that stands for National Permitting System for National Pollutant Discharge Elimination System permit is what that stands for. Those of you who have any familiarity with environmental law, you'll know that we very much like our acronyms, and it sometimes sounds like a different language. So NIPDES permits are often required for these facilities, and we touched on those briefly. Some other permits are required are Chapter 105 permits, which are typically invoked when there's a stream crossing necessary. Endangered Species Act reviews are necessary. We touch on those. We do that briefly in this chapter, and then again, we do it in much more detail in the appendices. So moving on to Chapter 3, which is where we get into the details about the solar lease. And we begin this chapter with an overview of the stages of solar leasing. It begins with the option stage, which typically lasts about 1 to 5 years. And this is covered by what's called an options agreement. And this options agreement can either be a part of the main lease or it can be a separate document. It really depends on how the developer approaches this phase. And during this phase, the developer pays the landowner an options payment to have the exclusive right to lease the property during this phase, to enable the developer to do the technical design work, to fully evaluate the land and to begin obtaining the necessary permits for the project. And much of the work done during this phase will be done behind the scenes. The developer, at least initially, will not have to do a lot of work on the land. They might do some measurements and the like, but they're going to be obtaining building permits, performing title searches, reviewing various interests in the land, like hunting leases and mineral rights, and planning construction generally. It's important to note that this option stage is very unilateral. The developer can choose to proceed or not to proceed at this point in their own discretion, depending on the circumstances that they discover as the project is developed. The landowner, though, is locked into the relationship after signing the options agreement. They cannot back out. They cannot offer their property to another company for a lease. This unilateral nature of the options agreement makes it very important for the landowner to obtain professional advice before signing the options agreement. And again, this is something I bring up. I'll bring up numerous times. This guidebook should not be a substitute for the landowner from obtaining professional advice. These leases are very long. They're typically about 60 pages. They're very complex, full of legalese. So we really do highly recommend that a landowner get some help to understand what they're committing themselves to for a 25 to 30 year time frame. Very important to get that advice. Then there's also the construction phase, which can last 3 or more months, depending on the characteristics of the land. Again, if there's a lot of vegetation that needs clearing or land grading, or construction of access roads that need to happen, that can extend the construction period. Supply chain issues can also come into play at this point. Upon completion, though, the landowner at this point, when the construction is done, they should expect a large fenced-in area on their property that excludes others, including themselves, from the entire area. Now, and we will get to in a bit, there might be some circumstances, particularly if agri-solar is involved, where the landowner will be allowed into the area, and that's a little bit more of a special circumstance that we'll cover in a bit. So after construction, there's the operational stage, which lasts for about 20 to 30 years. And this begins with the commercial production of electricity. And this is also when lease payments typically begin. And they could also begin when construction begins. It kind of can depend on the agreement a bit. But leases paid during the operational stage are on a per acre per year basis. And you can see here on the slide that that per acre per year price is about $800 to $1,500. And that's based on 2018 data. And I did do some research last night on that figure. And that figure stayed relatively stable, really depending on the source that you're looking at. So the data through 2020 at least indicates that those prices have remained somewhat stable. Now, the other thing to note here is that this price is the initial price. And one of the best practices we recommend here in this guide, and when we have clients that we're helping with lease review, is that there really should be a provision in the lease that upgrades these lease payments, notches them up over time to account for inflation. So there should be an increase over time. So in addition to all this, in Chapter 3, we also outlined some of the considerations at the end of the life of the project, so the decommissioning considerations. Those can include things like where the panels, the now defunct panels are disposed of, whether if there's a bond required to cover the costs of decommissioning, whether the recycling value of the materials at the close of the project can be used to offset the value of the bond, the condition of the property after the equipment is removed. These are all things that would be covered in the decommissioning section of the lease and should be thought through very carefully, especially if the landowner is a farmer and they want to return to farming that parcel after the solar equipment is removed. One other thing I would note here too, and it's something that comes up is that landowners often ask, will they get free electricity from this process? And I would note that they typically do not, although the lease payments that they get from this are often more than enough for them to purchase their own solar project or subscribe to a community solar project if that's available. So with that, I'm going to move on to discuss the components of a solar lease. And this is a continuation of what's in chapter 3. And I do think this is one of the more important chapters for the landowners to really review in this book. And we go through in some detail what the various components of a lease are. And we begin with the discussion of what the grant of the lease is. So the grant of the lease delineates the scope of the land to be leased, any improvements that might need to be made, any easements that might need to be granted, or the like. And in those easements, it'll typically include what's sometimes called a solar easement. And really what that means is that it prevents the landowner from erecting any structures or growing any vegetation in the vicinity of the solar project that would take away from the solar energy that's basically available to the panels. One thing to note here is that the final site plan of the project may or may not be delineated in the lease. It really depends on how far along the developer is in the planning process. Sometimes it might be included as an appendix or an attachment to the lease. Other times they might just list kind of basically what they intend to do in the identified portion of the land that's being leased. The basic lease rights included in the lease include things like the developer's right to exclusive use of the leased land. It'll delineate the purpose of the lease, which is to generate solar power in the area. It'll lay out the right to remove obstructions, either solar obstructions or access obstructions. It will lay out fencing and security monitoring provisions. It might lay out duty to cooperate, both the duty of the landowner to cooperate with the development process and the duty of the developer to cooperate with the landowner for any access issues that they may be experiencing. Of course, the lease will lay out the term of the lease, how long it lasts, and typically, again, that's about 25 to 30 years. They lay out the rent payments terms, and I did note earlier about how much that is. And again, there should be some sort of escalator for those payments to account for inflation over time. And why is that? Because an $800 per acre per year lease payment today in 2023 is going to look very different from an economic perspective in 2043 or 2048 at the close of the lease. So that there really should be a step up in those payments over time. One of the other things that's done in the lease is a clarification of the ownership of the solar equipment. And this may seem like common sense, but from a property law perspective, it's very necessary. Without this provision, the panels and equipment placed on the land might become considered a fixture of the land. And if anyone knows anything about property law, fixture on the land is a permanent piece of equipment or other thing, building or the like, that's added to the land that becomes a permanent part and it's part of the deed. That does not happen with solar projects, and the lease will very explicitly spell that out. Taxes are another thing that's covered in the leases, and that covers concepts like, well, who pays the base tax rate? Who pays the increased tax rate because of the addition of the solar panels? Who's responsible for paying back any clean and green solar tax credits that might be necessary if the property was enrolled in the clean and green program? So all those things should be spelled out in the lease explicitly. The lease will also contain a series of promises, covenants, and warranties, which are back and forth. It's mutual between the developer and the landowner. These are provisions like what type of insurance coverage that the developer will need to carry to protect the landowner as the project's developed. What type of indemnification provisions where the landowner is indemnifying the developer for their negligent acts that might damage the solar facility, and vice versa, where the developer is identifying the landowner for any negligent acts that might damage the landowner's property or agriculture operations, for instance. There'll be provisions for to confirm that the landowner has the right to lease the land. And this really addresses things like, well, it confirms that the landowner did that search to make sure that there's no hunting lease that gives some entity, like say a sportsman's club has a lease to be able to use that plot for hunting for the next 30 years. That might prevent the leasing and the warranty that landowners has to warrant in the lease process, that there's nothing out there that will prevent the lease from proceeding. There's provisions for quiet enjoyment, where the landowner and the developer have a right to quietly enjoy, meaning there's no disturbance of their ability to use whatever property they have a right to use. There'll be assignment protection from the landowner. This is pretty important because it prevents the developer from assigning the lease to a fly-by-night company. If there's going to be an assignment, the landowner has a right to have that assignment occur to a reputable company. There'll be provisions for agreement to cooperating during permitting and legal proceedings, force majeure provisions that says that if there's an act of God that prevents the contract from being specifically performed, that doesn't constitute a default. And then there'll also be provisions that define what a default is and what to do in the face of a default. Now, continuing on with Chapter 3 and some of the considerations that the landowner needs to keep in mind as they go through this process. And if you could change slides, Matt. So the landowner really does, as they're considering a lease, they really need to do their own research or get a professional to help them do that research. They need to know, research the company, know their track record, how long they've been operating. Have they done these types of projects before? Have they been sued for screwing over other landowners? Have they been sued for not following through with their commitments? Have there been any controversies? Are there news articles out there that might indicate that the developer isn't as reputable as you might think? Do they have the necessary professional training and certifications? Do they have the necessary insurance coverage? Are they local, or do they care about the local region? So the location that they're headquartered in matters. The landowner also needs to consider competing legal interests. And these are things that can interfere with leasing. I did mention the hunting leases again, but mortgages can interfere with leasing. Oil and gas leases, mineral rights, utility easements, conservation easements, depending on how they're worded, can prevent solar development. And again, there's also the government programs like the Clean and Green program that can interfere with leasing if not attended to. Then in Chapter 4, we review farming and rural land considerations. And this is where we talk about how a farmer can co-locate agricultural operations with the solar power generation. And that co-location of farming with solar power generation is often called agri-solar. That's one term for it. A newer term, sometimes I've heard it called agrivoltaics. I think I like agri-solar better. It rolls off the tongue a little bit better. And there are a bunch of different examples of what agri-solar is. And one of those is solar grazing. And solar grazing is really kind of limited to sheep. Sheep are the best kind of type of animal that can cohabitate, so to speak, with solar panels. Cows are too big. They can bump into the supports and knock the solar panels off track. Poultry can jump up on the panels and foul the panels and prevent them from getting the solar power. Goats also, if you know anything about goats, they really like to jump on things and they can jump up on the panels and damage them. So sheep are really limited to the main type of animal that can graze under panels. Although I've read some accounts of chicken grazing with chicken tractors, where there's like mobile enclosures that can be moved along, and the chickens stay in the mobile enclosure so that they can't get up on the panels. I've read about that happening as well. And the agri-solar, again, under a typical lease, the landowner is going to be excluded from the project site once, both during construction and once operation begins, unless there's some other contractual right allows them to conduct farming operations there. And that agri-solar agreement or solar grazing agreement, whatever you want to call it, it sometimes is part of the lease, but typically it's going to be a completely separate agreement. And there are some considerations we advise landowners and developers think through when they're entering into a solar grazing agreement. What type of fencing is required? There might be fencing required to exclude grazing animals from portions of the facility. There might be additional fencing required to do grazing rotations so that the animals don't have access to the entire facility at the same time, and the grazing can be rotated. What type of vegetation is planted under the panels to ensure that the grazing animals have the proper nutrition, making sure that the animals have an appropriate water source, and the number of grazing animals to not overwhelm the area. These are all things that should be considered and accounted for in an agri-solar contract. Another way to do agri-solar is pollinator-friendly practices. This can support things like growing flowers for commercial sale, apiaries. It could just be done as a government policy to support wildlife. And there are some governments that have formal policies to promote pollinator-friendly practices. 7 states actually have adopted policies towards that end. Those include Minnesota, Maryland, South Carolina, Vermont, Illinois, and Michigan. As you can see, Pennsylvania is not on that list, and we do make a pitch in the agreement, in the book to, urge Pennsylvania to adopt the pollinator-friendly practice for utility-scale solar. And it is possible to grow crops among solar panels. I've noted, flowers can be grown there. There's been projects where blueberries have been grown, alfalfa has been grown, and in places like Europe, where they're a little further along with their solar development, there's even full crop growth under solar panels, where the panels are lifted up high enough that other types of crops and equipment can be used underneath them. And we do really hope that comes to fruition here in Pennsylvania and the United States as we develop more solar. Now, this chapter also highlights a couple case studies. It highlights the Nittany 1 solar project done by Penn State and LightSource BP in Franklin County. That was a 70 megawatt facility with 150,000 panels. Now, if you recall, it takes about 5 acres per megawatt to produce solar power. So 70 megawatts, that's going to be about 350 acres. So that's a fairly large facility. And it accounts for about 25% of Penn State's electricity needs. We also highlight the Gaucho Solar Project, which is Pitt's project, and that's on the border of Beaver and Allegheny counties. It's a 20 megawatt facility, so about 100 acres, and it accounts for about 13% of Pitt's power needs. And in the case studies, we go in some detail about how those projects were developed, some of the obstacles they overcame, and other details. Then in chapter 5, we go over some, we make a pitch for community solar, describing its benefits for lower income people and for folks who don't have enough space to install their own solar. Talk about how favored it is by Pennsylvania voters. A recent poll indicated about 81% of Pennsylvania voters are in favor of this. So we make a pitch for the approval of an authorization of community solar in Pennsylvania. And in this chapter, we also go through some and bust some myths about solar. One of those is glare. Solar installations do not create glare. The point is to absorb light. Today's panels reflect as little as 2% of the light that hits them. So glare is just not an issue. Actually, solar panels create less glare than snow or windows or bodies of water. So it's just not an issue. Also noise. There's a myth that solar panels create a lot of noise. We bust that myth. They do not create noise. There are inverters attached to it that might create some noise, but it's not very loud. It's no louder than a conversation, and can be mitigated with noise barriers. There's also the myth that solar facilities drop nearby property values. We bust that myth as well. Current research indicates that there's a negligible effect on property values, and there's even some indications that the infrastructure improvements and boost to local economies caused by these projects actually do a good bit to boost local property values. Finally, you bust the myth that solar arrays contaminate the nearby soil. These arrays are fully sealed, and they're designed to endure all weather conditions over the course of 25 to 30 years. So nothing's really getting in them. And the materials that are used, 95% of the materials used are non-toxic, and we outline how any leaching that does occur is very minimal. And then we go into our appendices. So the first appendix, we go into some detail about the various permits that are needed, and components of permit that are needed for these large projects. And I'm not going to go into great detail about these now because we're quickly running out of time. But I will note that we go through E&S control plans, stormwater discharge permits, Chapter 105 water crossing permits and encroachment permits, the endangered species analysis process, how historical and archaeological sites are protected. And then we have some permitting flowcharts. And if you could go to the next slide here, Matt, these are what the permitting flowcharts look like. And this will help landowners understand, developers understand, anyone who's really using these books understand exactly what permits are necessary. If you go to the next slide, this next slide also it goes over how the endangered species and threatened species are dealt with in these projects. And then we have an appendix that goes over land use and zoning and describes local government authority, how easements are involved, how local lot coverage ordinances might come into play. And lot coverage ordinances limit how much of the lot can be covered by something. There's setback and height requirements that we go over, sunlight resource access protections that might be found in municipal ordinances, historical preservation rules, zoning, whether we describe what it means by zoning by right, whether when a conditional use permit is required or special exceptions required or variances. We also touch on property value impact assessments that might be required by municipality and what those look like. And then finally, in Appendix C, we include the full text of a model options agreement and lease agreement for people to understand and have an understanding of what they're going to encounter if one of these documents is presented to them. So with that, I'm happy to entertain any questions in the little bit of time that we have. So if anyone has any questions, I'm happy to answer those right now.
Well, I appreciate that, Michael, and the abundance of information that you've just shared is incredibly helpful. I do see, I'm not sure if we can entertain questions live via participants, but if you could put your question in the Q&A or in the chat, I've enabled that function. But I have a quick question. When is the best time for a landowner to reach out to a legal expert such as yourself on considerations of leasing their land if approached or considering or thinking about solar?
Well, I would say that the best time to reach out is the moment you're contacted by a developer, because you're going to want to start understanding the process before you're presented with a lease. Or at the very least, if you're presented with a lease to sign and review, that should be most certainly be the trigger for reaching out and getting professional advice.
Yeah, and I would encourage everybody with the background research and the team that Michael has. I don't think it's unfair to say that it would be encouraged to reach out to Michael and his team at Fair Shake. to learn more. One question that we received is a discussion on property tax increases and appraisal issues, given the fixture definition. So a definition, I guess, that was referenced on a fixture, on what a fixture is, and was wondering if you could discuss property tax increases and appraisal issues, if those, or talk a little bit more about that.
Sure. So the lease will have terms preventing any equipment from be considered a fixture. So when the lease is over, the value, there would need to be a reassessment essentially. So the value of the equipment installed on the property, okay, I'm seeing a little bit of an addendum to the question here. So after project installation. So it's really going to depend on the jurisdiction somewhat, like how the local jurisdiction handles their reassessments and when those are handled. And how, if there is a property tax increase, you're going to know about that beforehand through consultation with the municipality, and it should be accounted for in the lease terms. So the landowner should not be held responsible for those additional taxes that might accrue at the property.
Another quick question that just came through the chat was, are you working with developers as well? I'm not sure if that's divulging too much about some of your clients, but I think maybe a re-emphasis of your mission and the work that you've done, maybe.
Sure. Yeah, I'm not going to say that we wouldn't work with developers, but when we represent clients, our goal and our mission as a nonprofit organization is to provide access to justice. So we really heavily favor taking on clients that would not normally be able to get their own attorney. So that's low-income folks, people who might have trouble finding an attorney because the local attorneys are conflicted out of a case. Now, that being said, if a community group is in favor of solar, and they want to influence their local municipality to be more supportive of solar, we would work with the developer and the community group to help make that happen as part of our community democracy program. So we would help facilitate community education. We help negotiate community benefits agreements with community groups. So if a developer wants to work with us on negotiating a community benefit agreement, we would do that. We've had developers reach out to us to provide representation to landowners that need it. So they'll be a go-between to help a landowner get representation. So we're happy to be a referral source for developers. So there's ways we work with developers, but we typically we typically won't represent them directly, but we might cooperate with them as we represent clients, or help communities be proactive with supporting solar.
Thank you. And I think this is a good question. What happens if the solar leasing company goes bankrupt midstream of the contract? How could that impact the landowner?
Well, remember there was that assignment provision in the lease. So if a company goes bankrupt midstream, typically during that bankruptcy process, if the company is being liquidated, the rights to that lease will be sold as part of that liquidation. And under the assignment protection clause, it's going to require that the rights be sold to someone who's reputable and can execute on the contract and fulfill and specifically perform. So that would be ideally how it goes. I mean, obviously there could be practical issues and obstacles to how that works in reality, but that's the way it's designed to work, is that it would be sold to someone that's reputable. Now, if the company doesn't go is not liquidated as part of the bankruptcy process, they might follow through with that process. It might be delayed. And I think that's an important consideration, like, for instance, with the options agreements, there's a 5-year term on that typically. So if the company doesn't execute on the option within a certain period of time because they went bankrupt and they don't have the funds to do so, for instance, it will cancel the option after a certain time, and then the landowner can move on and potentially lease with another company if that's the situation.
Thanks, Michael. And I think that's a good place for us to start, and right on time as well. With the few of the questions that we still have in the Q&A, we'll certainly be able to follow up and make sure to reach out to Michael and his team if you have legal questions and want to continue the conversation. But thank you so much, Michael, for the presentation. Fantastic information, a very valuable and useful product and a tool for landowners and other solar stakeholders, so we can continue to educate and increase awareness about what resources do exist and ensure that solar development in Pennsylvania is done right. So next steps, please stay in touch with us here at the Solar Center. If seeking to advance policy, please call and encourage the action from our state legislators. We'll reconvene here in November on another solar policy topic, to be determined. But feel free to always contact us with any questions, concerns, issues, and anything solar related. But thank you again, everybody, for joining us, and look forward to seeing you all next time.
Thank you.